It's good to see old friends. Janet was just here until 2 days ago, so you must be all jet lagged. This is a very busy week here because we have also the digital assets project at the same time. So I'll be ducking in and out of both, and I apologize for that. It won't represent any lack of interest, because I think this is, technology and enforcement is the key to this project. It's the new thing in the world. Enforcement has failed miserably in many countries for hundreds of years, I'd say. And this is the thing that can make that change. And so I'm hopeful that we will be able to learn a lot from the experiences of those countries that have taken daring and audacious steps in modernizing their technology in enforcement, and it's fantastic. So I'll just hand it over to Catherine, and I am very much looking forward to this workshop. Thank you.
Thank you, Ignacio. I'm not going to take much time because I want us to get into this, but I just want to thank the Secretariat for organizing this, and thank all of you for participating. I thank you in advance because I'm sure this is going to be very interesting. It's really important for the working group on enforcement and for the enforcement project to have this workshop. It's the opportunity to just take a short time, yes, but just to take that time and focus on the developments. And all of this is going to feed back into the working group and help us make our best practices even better. So I thank you all for your contributions, and let's get on with this. Anna?
Thank you very much, Catherine, and thank you also, Ignacio. So, distinguished experts, ladies and gentlemen, and if I may, dear friends, greetings to all. I'm really delighted to moderate the first panel of this project workshop, and I wish to particularly thank, of course, all speakers for accepting UNIDROIT's invitations to participate, and all project members and observers who are present here. As you know, the project on best practices for effective enforcement seeks to develop guidance for legislators, particularly on enforcement procedures and mechanisms. And the speakers in the first panel, as Ignacio and Catherine have already said, will share with us updates on recent developments in enforcement law in different legal systems, particularly on how technology has affected traditional enforcement procedures, and whether there were, of course, any positive effects, and whether there were any challenges that had to be overcome. So, but you don't want to hear me. I would like to give immediately the floor to this first speaker, who honors us with her presence, is Ms. Amna El Owais, who is Chief Registrar and Chief Operating Officer at the Dubai International Financial Center Court. And she is also, among many other things, Deputy Registrar of the Special Tribunal related to Dubai World, Chairwoman of the DIFC Courts Users Committee, and she's a member of the Consulting Council for the University of Sharia College of Law. She's therefore in the best position to look at how the DIFC courts approach enforcement and whether technology made a difference. So please, Amna, you have the floor. I would like only to remind speakers that the utmost length of their intervention is 15 minutes. This is just to allow us to have a good debate after. Thank you very much. Amna, you have the floor.
Yes, thank you so much, Anna, for the introduction. I'm very humbled to be actually part of this discussion today, and I hope you learn from me like how I would actually learn from you all. It's such an honor again. I just wanted to share with you like our perspective. I've been with the DIFC courts for 16 years now, since 2006, so really from the early days of the creation of the Dubai International Financial Center and specifically the courts. And within the DIFC courts, we really focus on aspects in relation to judicial excellence, service excellence, connectivity, and innovation. And I believe for today's topic, it's really more about connectivity, as we believe enforcement is really about connecting with other jurisdictions, connecting with other stakeholders, whether private sector, public sector, and so forth. And in terms of the DIFC courts, in case you have not heard of us before, we are part of the financial jurisdiction. We're part of a free zone in Dubai, and we have jurisdiction over cases that arise within the center that has a link to the center, or the subject matter of the dispute occurred in the financial district. In addition, back in 2011, the DIFC court's jurisdiction has expanded. So like any other court around the world, like commercial courts of the UK, Singaporean courts, and so forth, we have become an opt-in jurisdiction. So any two parties that choose us in their contract, they can actually opt into the DIFC court for any commercial and civil disputes. So we are a commercial court rather than criminal. Criminal cases will be actually dealt with the normal onshore, of course, police, public prosecution, and the onshore Dubai courts. So we are a commercial court in nature, and we really think about our strategies, our day-to-day more from a business mindset. And we're quite fortunate to be such a young court where we can always have new developments absorbed within the team. Our judges are very much open to change. We are the first court to have virtual hearings, remote proceedings. We were quite actually fortunate, since we are a commercial court within an international nature with judges from around the world. We were actually fortunate that we had all of from the classical video conferencing facilities back in 2006, 7, 8, up to in 2016, when we really had our smart small claims tribunal through Skype for Business. And then we really developed our e-registry, and everything is really digital in the DIFC courts. And once the pandemic hit, we were able to convert into virtual setting within 24 hours, whether operational or core business from a judicial perspective. In terms of our topic today, enforcement, the DIFC courts has direct power of enforcement within the center and the DIFC, within the 110 acres within the center. So let's say we had a judgment to be enforced within the center, we have the direct enforcement through our enforcement officers, our bailiffs, and so forth. And we have, of course, renowned enforcement procedures and parts within our court rules. At the moment, whenever cases are required to, or let's say judgments to be enforced outside the DIFC, outside the free zone, we go through different mechanisms within the UAE. So I'll explain to you the UAE mechanism. So when we have a judgment that has assets to be enforced against within, let's say, Dubai, Abu Dhabi, within the 7 Emirates, we normally go through legal deputation or judicial deputation, which is normally the civil system, because in the UAE, it's a civil law country. Our judicial system is civil system, and we are a common law court. So basically we operate within the common law system like other common law jurisdictions. So when it comes to enforcement outside the DIFC courts, we follow their procedures. And actually, if I may, through judicial deputation, the enforcement creditor will go to the respective courts on the onshore courts, and then they follow their mechanism on enforcement. And of course, they have nothing to do with the judgment. They don't touch the judgment. It's fully enforceable, unappealable. So they only follow the procedures of enforcement. And in general, we have memoranda of understanding with all of the UAE counterparts, let's say the Ministry of Justice and other local courts. Within the UAE, we have federal court system. Within the Ministry of Justice, they fall under the ministry. And some emirates within the UAE chose to have local courts. And through them as well, we have memorandas that actually, let's say, make sure that we have the healthy relationship to make sure that our judgments are enforced in any way. By law, it's fully enforceable, since our judgments are actually judgments of the DIFC courts, and we are one of the UAE's court, and our judgments are actually issued by the name of the ruler of Dubai, Sheikh Mohammed bin Rashid. And then the next level to take you through regional and global enforcement. So again, we are very fortunate as a court. We are a common law island within a civil law ocean. So within the DIFC courts, we are fortunate to get the value and benefit of all treaties that the UAE has entered into. So like any other court system in the world, let's say in Canada, any treaty that Canada would enter into for enforcement, all the courts within Canada will actually get the benefit of those treaties. Likewise, being part of the free zone doesn't mean that we are carved out from such treaties. Well, we actually get the benefit of utilizing those enforcement treaties for our favor. So we normally are automatically following such treaties. So our lawyers, our creditors, judgment creditors really get that benefit. So let's say UAE enters into a treaty with, let's say, Spain, then we are actually part of those treaties for enforcement, similar to the New York Convention and so forth. So within the UAE, there are, of course, many international treaties, in addition to the Riyadh Convention, which is more for the Arab world, in addition to the Gulf Council countries, where we also get that benefit. So we are really getting the best of both worlds. Since we are a common law court, we also get the reciprocal arrangement with other common law jurisdictions. So let's say the English courts, Australian courts, Singaporean courts. In the absence of a treaty from a country, let's say a wide treaty from UAE to, let's say, Singapore, where I believe they do have a treaty. Let's say the scenario, there wasn't a treaty, let's say the UK. What would happen in our situation, and since we are a common law court, all other common law jurisdictions honor our judgment, and they would actually enforce it straight away without any questioning. And with that, we believe we are one of the most connected courts in the world for those reasons, because of our special nature. So as I mentioned, for 3 reasons why we are the most connected. First of all, because we're part of the UAE. So all treaties that the UAE has entered into, we get the benefit of in terms of enforcement. Second of all, since we are a common law jurisdiction, as the DIFC court is a common law court, we get the value of all common law jurisdictions honoring our judgments. And that is actually tested, tried and tested. We have many precedents that actually show how other courts around the world, whether civil country or common law jurisdictions, actually honor our judgments. And that is really a huge testament in terms of our court system. Since it's a young court, we barely have been in business, let's say, for about 17 years. And through that, we are really fortunate that we have the best regimes that actually back us all the way in terms of enforcement, because at the end of the day, you don't want a judgment on paper, right? You need a judgment that can be converted into money. And that is very important for a court that operates as a commercial and civil law court. So in terms of our relationships with other jurisdictions, whether in the UAE or abroad, we really invest a lot of time in maintaining the relationships that we have. And back in 2016, we started this new exercise of connecting with other jurisdictions, irrespective if we have a treaty with them or not. And we started this new model of memoranda of guidance. And as of today, I believe we have more than 15 signed with different jurisdictions, lots of mature jurisdictions, like in Australia, with the Western Courts of Australia, with the Federal Courts of Australia, Singapore, China had the first Shanghai High People's Court signed with us. So this was really a landmark exercise for us, because we were quite, shocked to the receiving of those countries, our courts within those countries, to the DIFC court, the tiny courts in Dubai that has been just established. So for us, that was a really good exercise, because it gave our users, our business stakeholders, as in people who actually choose the DIFC courses, since it's a forum of choice, that was quite important to show them the certainty that they can get in terms of enforcement. So in the memoranda, it's quite a guide. It's not legally binding. What it does is, let's say we signed with the Singaporean court, it will show if there was a judgment to be enforced from Singapore within the DIFC, where the judgment creditor needs to enforce against the judgment debtor in the DIFC, what steps to be taken, in perspective in terms of our rules and procedures, and vice versa. If there was a judgment debtor in Singapore and we have a DIFC court judgment, how would the steps of enforcement work? So this is really, in a nutshell, how we were able to really, let's say, hit enforcement on the nail by having the benefit of common law reciprocity, by being part of the UAE, where, of course, we get the benefit of all those treaties. And last but not least, the memoranda of guidance that actually really helped us with maintaining relationships and giving our stakeholders and court users the right, let's say, the easy guide of how and when and how would you actually secure the process of enforcement in other jurisdictions. And last but not least, I don't want to basically step on anyone's toes for panel 2, where they will focus on technology. As back in 2018, we created this initiative called Courts of the Blockchain. Many people at that point thought that that meant we handle blockchain cases or disputes. That's not the case. That was not really intended through this initiative. We do handle technology and construction disputes, which can include cryptocurrency, blockchain, and all of that. And actually, in December 2021, we issued a newer division, which is called Digital Economy Court. And with that, we're going to do a lot of new developments as far as new precedents and parties choosing the DIC courts for digital economy court types of disputes. But courts of the blockchain, since blockchain had huge, let's say, trend back in 2015, 2014, many people were talking about blockchain, and we wanted to be part of that wave. But we realized, you know what, blockchain is not the solution for all problems. And we realized that blockchain is quite important for cross-border enforcement. In addition, if you are part of the smart part of smart contracts as the supply chain, whenever a party defaults, blockchain kicks in, and then you can actually automate the process of enforcing judgments when there's a default by any of the parties. So this is in a high level. We are still exploring this area of how we can actually we don't have still the tangible solution, since we need stakeholders from around the world to be part of this blockchain for enforcement. We can't actually build the whole platform. We need courts and jurisdictions from different court systems around the world to actually link in, and in that way only we can actually enforce judgment through blockchain. And we did really a lot of work lately. All of our judgments are encrypted, and there's a barcode to show and prove authenticity of the document. So this is actually one piece of the puzzle, and we're working towards that vision. One day, blockchain will be used for enforcement, which will make things easier, efficient, and people's rights protected, and they can always have that safety net that they need. I hope with that you enjoyed my time. I hope I didn't pass the time. I think I'm even short. So I hope you enjoyed my intervention.
Thank you very much, Amna. Yes, we did enjoy it. Thank you very much. Lots of new information. I would personally have a lot of questions on what you have told us. I see that you have also prepared some useful links that I hope you will allow us to share with the participants. So we leave questions or comments for the end of this particular panel. And so allow me to get to the second speaker in the panel, Miss Lina Lontone, who, as you know, is an observer in our working group. She's currently the media representative at the Council of Sworn Bailiffs of Latvia and judicial officer's assistant to judicial officer in Beta Kruka since 2016. And she will speak about technology as applied to enforcement, in particular in Latvia. So, Lina, you have the floor.
Thank you. And I think you can see my screen, right?
Yes, we can.
Okay. So, yes, dear colleagues, I'm very happy to join you today. Especially, it's very great to switch off my brain through the many events that are happening right in our neighborhood. So today I will be sharing with you our experience with e-auctions and e-case. I will focus more on e-auction, as that is system platform that we know for a longer period of time, since we're working with that since 2015. So yeah, about e-auctions. This is platform that is a module part of the Register of Executive Cases, which is basically state information system that is intended to perform the duties of judicial officer, which is yeah, basically unified record keeping system. And that is mandatory for all judicial officers to do their job. And the holder and operator of this module is the court administration, and that is directly connected to this register of executive cases. And who can access this register? Only judicial officers, their assistants, and other office workers, members that need the system in order to do their duties, to do their job. So in case of data privacy and who has access to data, it's very limited scope of people. And the whole system is owned by the state. I thought it is important to start in general who can access the platform of e-auctions. So first of all, these are unregistered users who basically can see advertisements on the website that you can see in the slide in, so to speak, viewers mode. They can see the advertisement when the auction is happening, what kind of auction that is, and what is the current highest bid, and what is the result of the auction. Then there are registered users that are registered to the system of auction. Registered users doesn't mean that these people are automatically registered to the auctions, but it means that these persons, or entities presented are authorized, and they are legit and credible, and everything is okay with them. And then there are bidders, these persons who are already authorized to join the particular auction. And then there are, of course, judicial officers and their assistants who use the platform through the register of executive cases, and who prepares the advertisements, and who authorizes the participants, and so on. And then there are platform administrator, which is the court administration, who checks whether everything technically works okay, is safe, and so on. So how to register to the e-auction platform? There are basically two options. A person who is resident of Latvia and who has electronic ID card or electronic signature or internet bank can authorize through this website Latvia LV, which is credible way how to present that I am this particular person or representative of this particular person. Or a person can go to Office of a Judicial Officer and ask to register them directly through Judicial Officer. And legal entities and other that's not irrelevant what I wanted to say. And so this is how e-auctions looks from the side of judicial officers in reality, in practice. On the left side, you can see particular executive case. Of course, I wanted to share my screen through the system and show more specifically how it works, but then I realized it will not be okay through perspective of data protection, so we have only these pictures. So yeah, this is the screen, the working place of particular executive case, where we see how big is the debt, who's the debtor, who's creditor, what kind of assets that or actives a particular person has. And then we have this section where we can create an advertisement of auction. And this is how it looks. There is all the necessary and relevant information that is mandatory for the announcement of auction. And once we fill it in here, it will be directly sent to the website of e-auction of this platform, where people will be able to see all the information and the advertisements about current auctions. And it will be also directly sent to official Gazette, Latvia's Vēstnesis, or Latvian Journal, where also will be this advertisement about about particular auction. And here you can see how this advertisement looks on the e-platform of e-auction platform. And this is the same advertisement. On the top, it's in Latvian, and on the bottom, it should be translated to English. But this is one of the challenge that we have because, you know, as you can see, translation is with errors, but in general, it's meant to be both in Latvian and in English. And yeah, so when person sees that they want to apply for the auction, they register if they're not registered to the platform, and then they ask to authorize them to judicial officer. That all is happening through this system, and within 24 hours after judicial officer receives this request to join the auction, and when the fee of participation and deposit is paid and already received in the deposit account of a judicial officer accepts this person to join the auction. And the whole auction process is happening for 30 days if that is immovable property, and person can ask to be authorized for the auction till the 20th day of the auction. What is important to keep in mind that what asking for authorization means is that, first of all, there has to be a request through the system, and second of all, administration fee and deposit fee for the auction has to be on that 20th day in the deposit account of judicial officer. If the request will be on the 20th and the money will go in on the 21st day, that person will not be able to join particular auction. Also, yeah, important question, I guess, can non-residents of Latvia join the auctions? Yes, anyone can join, but what we should keep in mind is general restrictions that has to be taken in account. For instance, if there are specific rulings who can or cannot buy agricultural land, or I don't know, if someone is selling guns, then of course, you know, there has to be things that are need to taken in mind, who can and who cannot buy particular assets, but in general, anyone can join. Bidding, of course, is also done only electronically. And there are basically two options: do that manually, which is by clicking the button to bid, and amount of bid is fixed in an announcement. It cannot be larger than 10% of initial price. And registered bids may not be revoked or changed, and bids are registered chronologically. Also, yeah, there can be manual bidding, but there can also be used auction agents or automatic auction steps, which means, and that is thing that you can do for additional price. So bidding is done for you. For instance, you say that your maximum bid will be 300 euros, and this bid will go on and on and on if someone bids in between. And there is also important parity principle. In this example, for instance, you can see that last bids are done in the same time, but this system is precise to the milliseconds. So whenever whoever will be the last to bid, even, you know, millisecond later, that will be the winner of the auction. Yeah, this is also important question, I believe, because obviously as we approached our system to e-auctions, this is new basis for declaring an auction of not having taken place if there has been significant security or technical failures. You can see these three situations where a particular situation can be declared as technical failure, but there can be also other situations. For instance, recently in my practice, there was a situation when for whatever reason, advertisement didn't appear on the e-auction platform. And actually potential participant told us that because the person saw the advertisement on this official gazette but didn't see that on the auction platform. So we stopped the auction and we immediately announced new one. Benefits and challenges. This system is absolutely transparent, anonymous, and uninfluenceable. And what I mean by uninfluenceable, before e-auctions, we had real in-person auctions. And of course, they looked great as in the movies, but there was this so-called auction racket when deals were made between participants, and it was just not to how it's supposed to go. And there were many ways how to do fraud and so on. And in the same moment when e-auctions were announced, when we transitioned to these e-auction platform and system, bidding values at least doubled. And that is quite significant change. And also during COVID-19 era, I think it's also a very important factor that we were able to work as before and without any interruptions or influence on a particular executive case. And from the challenges, as I already mentioned before, I would say language issue, because of course, auctions are open for everybody, but the platform is translated to English at this point, or only partially, and with mistakes, obviously, and also digital gap. It is an issue in Latvia in general that there are a lot of people who don't have this digital literacy. And it's not only about obviously auctions, but about other digital platforms as well. So they are kind of excluded from this system, and this also has to be taken in account. So that person needs to have at least some digital literacy to participate in these auctions. So this can also be seen as a challenge. And very briefly about eCase, that is a new system. And so that is basically unified electronic platform within branch of whole judicial system, which has been made to create all processes more transparent, faster, and easier to understand, both for practitioners and for people involved. And what eCase means for us, judicial officers or people who work in enforcement area, is that since 1st of December 2021, we are receiving enforcement documents issued by courts or administrative institutions directly to our register of executive cases, which is also very great because a person don't need to physically go to court or other institution to receive this enforcement document. Also, since we are receiving it electronically, that document stays electronic and stays in the system, and whether case has been finished because the amount has been recovered or it has been transformed to another judicial officer, all the details are in the system. So we don't need to write physically down on executive paper how big amount of money has been recovered. It is all in system. It's very transferable and simple, and it's very traceable. So that's very briefly about this eCase. So far it works good. I have nothing bad to say, but it's only 4 months. And so this will be it from me, I guess. If you have any questions, I think we have time for questions later. So thank you.
Thank you so much, Lina. Thank you also to remain within the time as Anna did, and so as to allow questions and answers from you. It's actually, I would have some questions myself. Let's leave them to the end. And let's go to the third speaker today. And the third speaker is again, well known to the members of this working group. He is the first vice president of the International Union of Judicial Officers, which, as we know, is a global organization. He has been an enforcement officer for over 25 years and has participated in legal reform, academic teaching, very active observer in our working group, and he will talk about particularly the Code of Digital Enforcement, which was developed by the UIHJ. So, Jos, you have the floor.
Now I'm unmuted, I think. Thank you very much, Anna. Well, I will try to stay within the time that is given, but please remind me, because if I start talking, I always know when I start talking, but I never know when I stop talking. Honestly, I'm very jealous about the system as it is developed in Latvia, and we see a lot of shortcomings in that respect, also in the other countries. Maybe just before we start, for those that are not familiar yet with regard to the UIHJ, the International Union of Judicial Officers, we were established in 1952. And well, ever since we try to represent judicial officers, enforcement agents from all over the world, as Anna was mentioning. So currently we have more than 100 member countries. In 2015, we started with the development of a set of international standards in the field of enforcement. We call that the code, the Global Code of Enforcement, and as a code consists of different books. The 2015 we consider this as a kind of book one with the general principles, and that was followed in last year in 2021 during the UIHJ Congress in Dubai. We presented the second part, the Global Code on Digital Enforcement. I would like to go a bit, but also to mention some links with practical examples. What is very much of importance, and what was also mentioned in the digital, in the Code on Digital Enforcement, is I would say a number of general principles with regard to human rights, but you also have a number of principles that are, I think, specific if you talk about digital enforcement. First one is, I think, I just highlighted a few. First one, I think, which is very much of importance, is respect for human dignity. Also, if you talk about digital enforcement, we have to be careful, and Lina was already mentioning the digital gap that exists for some people that are not that familiar with digitization, etc. And I think it's very much of importance that also those interests of those people are also protected. The second issue, important, is also, especially in digital enforcement, is respect for personal data and privacy. We have to be careful in how are we dealing with digitization. We must guarantee the confidentiality of data, anonymization of personal profiles, for example. Well, the example was just given with regard to e-auction, that you cannot simply make a print screen, because you have to be very careful if you talk about personal data. A third issue is, I think, with regard to social responsibility of the developers. That also refers, for example, to the development of algorithms. Well, honestly, we have some bad experiences in the development of algorithms in the Netherlands, especially by the enforcement through the tax authorities, making algorithms where they used a kind of system of profiling. And of course, that's something that should never happen. And that is also another issue, I would say, a fundamental right of parties, if you talk about digital enforcement, that is the trust that people should have and need to have in digital enforcement. Especially, I gave already the example in that respect of the algorithms. They have to be reliable, they have to be robust enough to face mistakes, and they have to be able to be corrected, those algorithms. And a last thing, I think very much of importance, is technological neutrality. We have to be neutral, for example, in the use of algorithms. So profiling, of course, should be out of the question. At the same time, we also have to be careful in how are we going to use digital enforcement. Does it mean that digital enforcement should be a complete replacement of traditional enforcement? I would not think so. And that makes also that at a certain moment, enforcement agents will have to make a choice. Should I, in a specific case, should I use the direction of digital enforcement, or should I choose for the traditional enforcement? Again, that is a consideration the enforcement agent then has to make based on a number of questions the enforcement agent has to ask him or herself. We're talking then about issues like proportionality. What is more proportional? The principle of proportionality in digital enforcement versus traditional enforcement. We have to look at the rights and the protection of parties and third parties. We need to have a look at the obligations on the one hand of debtors to cooperate, and on the other hand, maybe also the gap that there is, the digital gap that a number of debtors have. And at the same time, if we talk about the enforcement agents, we have to take into consideration always that there is an obligation of enforcement agents to cooperate. They cannot refuse a case. It is important, that's also mentioned in the digital code, that enforcement agents, of course, are allowed to use certain digital tools. But digital tools, what does it mean? And I'm not talking about the attachment on the digital assets, that because that will go, that will come later. But for example, also not only the digitized attachment procedures, but also enabling, for example, online mediation or enabling amicable settlement of the case through digitization. It also means for the enforcement agent access to digitized registers, which for the moment is in a lot of countries still a shortcoming, let alone the access to the digitized registers, but let alone also that there is completely no interoperability with the systems as they are used by enforcement agents. Well, I already mentioned other aspects such as the use of personal data, which is also very much of importance. And I think another aspect that should not be forgotten is the costs of digital enforcement. And as it is the case with regard to traditional enforcement, also the costs of digital enforcement need to be well defined, need to be predictable, and as in traditional enforcement, need to be transparent and reasonable. also, again, this is very much of importance. Well, at the same time, if you have a look at e-enforcement environment, I think we still see a number of barriers in countries. I already mentioned the technical barriers that there are. In a lot of countries, the enforcement system is more or less isolated from the other systems that are used in justice, but also systems that are necessary, for example, with regard to the access on information on the assets of the debtor, or there is just a limited use, for example, of digital signatures. There is a need for security, there is a need for electronic exchange, which in a lot of countries still does not exist. Legal barriers, yes, they also still play a role. We see that there is, for example, in a lot of countries, still a lack of possibility to verify the authenticity of electronic documents. Again, there it is important that legislation is developed. Information barriers there are, I already mentioned them, there's insufficient information available for the enforcement agents. For example, access to information on the debtor's domicile or the location of property, it's still very complicated. If I take the example of Germany, where we see that domicile registers are not organized. Somebody
I think, Ignacio, maybe you have to.
It's working now.
Perfect.
If, for example, in Germany, we see that domicile registers are not centralized. That means we have to go to each individual lender in Germany in order to obtain information. They are also completely not interoperable with each other. Cost constraints still exist also, if you talk about it. And finally, an important barrier is also the limited trust there is in dematerialized exchanges. Limited trust, not specifically within the enforcement profession, but we see a limited trust, for example, also from the courts, especially with all respect, elderly judges sometimes have a lot of problems with the automation and digitization, but also other authorities or in general citizens might have a problem with that. Just to give an example of a barrier, and that's why I'm also mentioning that I was jealous on the system that is in place in Lina, that Lina was mentioning in Latvia, is that if we have a look at a lot of countries, we did it some years ago in 8 EU member states, and what we noticed there, that enforcement simply is not part of the overall e-justice strategy of the government. That means that it makes it also very complicated to develop digital enforcement tools. In some countries, I can mention the example of Bulgaria, it's simply up to the profession itself to develop such e-enforcement tools without any assistance or financial assistance of the government. That makes it very complicated. Even though we are talking on self-employed or private enforcement, there is an important role of the government also to have enforcement implemented in an overall e-justice strategy, as, for example, is the case if we talk about the Baltic states. And there it is very well organized also. We see that, for example, in the Baltics, there is just one case management system, whereas you see in a lot of other countries, enforcement agents are completely free in the choice for a certain case management system. And at the end, of course, that appears to be much more expensive, much more problems also in doing investments in the development of such a case management system. Financial funds are very limited. Additional problems are there also. Again, with regard to interoperability, if there are different case management systems in a country, how can we connect those different systems then to the databases with regard to the assets? But it's also more complicated than to develop, for example, the central debtors register, or a public auction register, the e-auction register, or a filing and data processing system, just to mention some things. So it is important, if we talk about digital assets, that those minimum requirements for a case management system are defined in principles and also worked out into practice. Another thing, and I already mentioned that, see that I forgot to change the slide. Another thing I think that's very much of importance is participatory enforcement. So not just enforcement by doing attachments or automatically doing attachments, digital attachment, like, for example, the attachment on a bank account, but also we need to continue to keep an eye on the human factor. Also, if we talk about digital enforcement, we've seen that, especially if we talk about the COVID-19 crisis, allowing payment in installments, making payment arrangements with the debtor, for example, is very much of importance. And these tools need to continue to exist also if we talk about technological innovations. With regard to cross-border enforcement, we see that countries are not paying a lot of attention to the cross-border aspects of enforcement. They are shielding themselves on a national level only. Whereas if we look at what will be the future of enforcement, if you talk about the enforcement on digital assets, it will become more and more important to keep an eye on cross-border enforcement. And that will also be vital in digital developments in that respect. We need to cooperate much more. I mean, digital assets are used by parties all over the world. They are not bounded by geographical borders. So there again, the cross-border aspect is very much of importance. Well, the interoperability, I already mentioned that with regard to the case management systems, etc. I think another aspect that is of importance is the monitoring and control over the profession. Digital enforcement, one case management, digitized case management system should very much also facilitate the oversight and supervision over the enforcement profession. And what we see currently is that there is a complete lack of capacity in all countries when it comes to this monitoring and control. On the other hand, it is very vital also. So there also attention has to be given. Another aspect is with regard to e-service of documents. E-service of documents, electronic judicial address, does it exist? Slowly, there are some developments with a, let's say, official email address in the Baltic states, but we still see that it is little developed in most of the countries. There again, attention has to be given on the development of a well-functioning e-service system. That means also, if we talk about that it is very much of importance to have an authentic source for the records of the notification through e-service. And I think that will be, as it is already the case in a system that is developed in Belgium, that will be an important task also for the enforcement agent in future. e-service should be connected and also with traditional enforcement. So if there is no guarantee that e-service was successful, it again has to be served, notified traditionally. E-access to information, I think I already mentioned that. If I have 2 minutes more, then I can mention also with regard to the attachment. I will not mention the digital assets and the attachment on digital assets, but an interesting trend currently is in England and Wales, where the court had to make a decision on virtual enforcement. And that's a completely new trend. So virtual enforcement means there is assistance by the debtor through a camera, for example, and then through the screen, the enforcement agent is attaching those movables. And it's a complete new trend, and it is allowed in England and Wales. So I'm very curious to see how this will develop also in future. It's also a very dangerous development, to be honest, because traditionally the enforcement agent needed to have a physical entry to the premises to take control over the goods, and that now completely disappears in that respect. So I gave an overview of what is mentioned in the Code on Digital Enforcement. I hope with some practical examples also, but there is still a lot of work to be done, and well, developments are going very quickly, and we have to continue to keep an eye on that. Thank you.
Thank you so much, Jos. Thank you. Everything that you said was extremely interesting, and I was extremely interested. But allow me now to pass the floor to the last speaker in this panel. Otherwise, we will leave too little time for the next panel and for the discussion. So Veronica Bradautanu is currently advisor to the Ministry of Justice of Moldova, and she was formerly counsel in the legal department of the European Bank for Reconstruction and Development, which is a very active observer in our working group, but she will continue to follow the work of our group in her new capacity. She is currently responsible for the Ministry of Justice policy activities related to digitization in the area of enforcement, judiciary, and mediation. So we are eager to listen to you, Veronica.
Thank you very much for this introduction, Anna. And it's really good to see you all and speak English, surprisingly. So greetings to you all. And I'm very grateful for the invitation to be part of this panel and speak to you. Indeed, as my Latvian colleague mentioned, it's a bit difficult to concentrate on any other things in this part of the world, unfortunately. But it is a good opportunity to think of some other things. It is also today the 8th of March, the International Women's Day. So good wishes to all you women on this panel, and also to all the women around you. I know that in the UK, where I used to live before, it wasn't a big holiday or celebration, but in this part of the world, it's quite big. So today is a public holiday, actually, in Moldova, and the same in many countries around us. So back to our conversation, I was planning to speak today about digital advancements, or more to speak about issues in Moldova and Ukraine. Unfortunately, when we were planning this, what happened was unthinkable, but let's hope that very soon Ukraine will be back to advancing in the digital world as it did before. So I will start with Moldova, which is the country I'm in now. And despite the fact that Moldova is quite advanced on some of the digital platforms, especially on the government level, some payment systems for government services, other government services, registries, and so on, in the area of enforcement, it's not as great. And I see Jos is laughing, as he's been a keen participant in the Moldovan enforcement framework. And yes, indeed, it's didn't develop much. And I will focus on 3 areas in Moldova. And I think I'm the least disciplined participant today, as I didn't prepare any slides. But I will try to entertain you with sharing my screen anyway, by showing you the websites of the organizations I'm going to talk about. So the first, I wanted to speak about the case management system for the enforcement officers in Moldova. This is a contended issue, and it has been developed. Just to give you some context, the enforcement officers in Moldova are a private profession. So they are private bailiffs, but they do have some devolved powers, state powers, to them, and they are monitored by the Ministry of Justice, limited monitoring. So they're a self-regulatory organization. They have a union of enforcement officers, which is putting in place the rules for the officers and disciplining them. But the Ministry of Justice also has some attributions, like setting policies for them and issuing licenses, which is a formality really, and some other moments. And one of the responsibilities of the Ministry of Justice was to prepare this case management system or register, public register for enforcement officers. And for some historical reasons, they never managed to do that, or they started and the money disappeared somewhere, but no system was created. So the Moldovan enforcement officers, since they did need a system like that, they have created it with their own forces, paid for it, and put it in place. However, and they're working with this, but not all of them. So about 70% of enforcement officers are using the case management system. And I'm sure they would be very jealous of the Latvian system if they saw how it works. And perhaps Latvia will be willing to share some of the experience that they had. So the case management system that they have developed is a good system, but it in tune with what they wanted it for. It is more of a case management rather than a register, as it would have been, have it been developed by with the participation of the state. And because it wasn't developed as a public register, it doesn't have a legal framework. And the Ministry of Justice now is, in a way, in a sort of negotiation with the enforcement officers on trying to put in place this legal framework. And what it would mean is that this system becomes a public register, and it has to be owned by the state and administered by the state. And this is something that is not very appealing to the enforcement officers, because they have paid for this system. So this is one of the issues which we are looking an answer for, and how. It was interesting to hear that in Latvia it is a state-owned management system, and I was wondering how the profession is organized in Latvia, whether it's a private or public profession. So it's a well-developed case management system. It has it does some of the work, but it's not interoperable. It's not connected to any registers directly. It's not connected to the payment system directly. It's not connected to the judicial system because it lacks this legal framework. So the issue of ownership is perhaps something that we should also pay attention to in our work in this guidance that we are developing. So as promised, I will share my screen and entertain you with the website of the, sorry. Here you go. So this is the website of the Union of Enforcement Officers in Moldova. Google has kindly translated it for me in English. And as you can see, it's very basic. There is no statistical information, which is another thing that the public register perhaps would have helped resolve. There is no, although there is word auction, there is no auction. It's nothing there, as you can see. So it's mostly a very basic website that does not give any information to the users, maybe some information to the enforcement officers. So let me speak about another system that the enforcement officers have tried to develop. And this was a channel to communicate with the banks and try to enforce against bank accounts. Again, they tried just again to give you some context, there are 11 banks in Moldova, so not too many, and enforcement officers are basically inundating these banks with their requests. So each bank, perhaps per month, receives about 3,800 requests from the enforcement officers, and this is all done on paper or via email. But still, it's a lot of work, and the banks are very concerned because they have to dedicate an entire resource just to deal with these requests. And they tried to create this channel, but they decided to do it very quickly, and EBRD was trying to help them create this system, a separate communication channel with the banks and the enforcement officers. But the banks decided to use the state fiscal system, so the system of the fiscal service in Moldova, which is also a big creditor, which made it slightly interesting. The things that Jos was talking about, confidentiality and data protection, was not really considered in this exercise, and there was no legal framework for this channel. They've created it, but out of all enforcement officers, only 6, I think, are using it. So again, the framework for this communication is something perhaps to think about. And as I will speak also about Ukraine, where they have created this system of communication with the banks. And it's a separate direct system where the enforcement officers directly have a channel of communication, but they still did not create some sort of mechanism where the enforcement officers would know in which bank the debtor has bank accounts. So they're still sending the requests to all the banks at the same time, and the banks have to answer. So it's more like an email system rather than a more automatized access to information about bank accounts. I was also planning to just say a few words about the digital assets and enforcing against digital assets in Moldova, and looking at the time, perhaps I should mention at the same time about Ukraine. So in Moldova, it's a completely wild territory. There is no law. no clear regulation, no guidance on how to enforce against cryptocurrencies or other digital assets. And this is something that needs attention. In Ukraine, they are a little bit more advanced. They have a law on digital assets, so which clarifies a little bit the situation. But unfortunately, also there is no clear guidance on how to go against cryptocurrencies. And in current situation, as we understand that a lot of assets are being hidden into cryptocurrencies, this would be a good opportunity to pay attention to this and to try and clarify what to do about it. So I would turn now to Ukraine, and I think I mentioned the communication with the banks. I mentioned the cryptocurrencies. I think the one achievement of Ukrainians, which I wanted to talk about today, is the electronic auctions, which is a very well-developed system, and it's ProZorro Sale. And let me share their website with you. And they have, it's a very innovative system. So it's based on their procurement system. So basically they have this database where all the information is placed, but then this information is distributed to marketplaces. This is what you see on your screen. They also called administrators. And through them, basically these are small platforms which deliver this information to the clients, to the potential bidders. And they also offer services like notification, or maybe some explaining, or some information provision to the bidders. And by this, they're competing. So this is a good system for big markets, because in Ukraine, they have 40 platforms who participate and compete with each other for this access to this central database of information. And this offers them an opportunity to deliver good service to the bidders, but also it removes from the state the weight of administering or paying for the administration of this system, because all these marketplaces are contributing a small fee for the maintenance of the auction system. So, and one additional feature is this open data, which is something that then journalists or non-government organizations can follow and see if the process is well done, if there are any problems, and generally look at the data and compare the results. So it's an innovative and very well created way of auctioning. And it's not just applicable to enforcement officers. So it's a wider platform for any type of auctions in many other areas. So it's also used for non-performing loans, for enforcement in mortgages, and some other areas, any other auctions. So this is one really good achievement in the area, and they show you how many sales they had and how many years they have been working. So this is what I wanted to tell you about the achievements and also issues in this region. And I hope that our best practices will address some of them and will be helpful to us in developing the policies and regulations in these areas. Thank you very much.
Thank you. Thank you very much, Veronica. Yes, indeed, it was important on the one hand to see good examples, mechanisms that might be used as best practices, but also to see where those best practices might be useful, so where the problems are and the challenges are. So thank you, Veronica. Now, I would really like to leave sufficient time for the second panel, so that there is a discussion and sufficient time for the speakers also to present in the second panel. But we do have some time now for questions or comments. I see that Fernando has already raised his hand, so I'll give the floor to him. And there was already one question from Veronica directly to Lina, I think. So first, Fernando.
Good afternoon, everybody. Thanks, Anna, and thanks for the four of persons who presented the topics. It was really interesting to listen to all of you. And it won't take long at all because, I mean, there were overall descriptions. But I had one question for Lina regarding the things, how they're working in her country, Latvia, with these e-auctions, because we have the same system in Spain. Since 2015, and I saw just the image you put on the screenshot you put. Can you advertise pictures of the items which are being sold? First question. Second question, do you sell only land or other assets like cars or I don't know, commodities? And when you sell land, is it possible for any interested person to buy the property to have a visit on the premises before bidding? Because I mean, in the practice of my country, those are the main obstacles for the practical effectiveness. Nobody wants to buy a property without having been able to inspect it, unless it is only for speculative purposes. So I mean, they don't care what's inside. They just buy lots of things and they believe in the global, everything will be profitable. But when we think of a young couple who wants to buy an apartment to start living, and they believe buying it in a public auction will be cheaper than otherwise, having a look at it, it's important. So the pictures, possibility to visit the premises, and of course, if you sell other things like cars or vehicles, the possibility also to see and to submit to some kind of check the state of the sold or to be sold assets. Thanks. And thanks, I mean, also to Veronica and to Josh and to Amna for the very interesting presentations. Amna, I'm willing to visit the AFC courts. I believe it's like moving 30 years into the future. I was really jealous to hear to that. But for the moment, I'd like to see how it works in Latvia, because I think it's working right away. And I don't know if you have encountered the same difficulties we have. Thanks.
Should I answer now?
Yes, maybe that's a good idea. And then we go on to the other questions. Thank you.
Okay, so yes, we can sell other things as immovable properties, whatever can be registered and we have access to those assets we can sell, whether that's car, whether that's whatever that is. About ability, for instance, to see immovable property. We have this saying in Latvian, "Pērckaki, which basically means to buy a cat in a basket." So it really depends on the person, how communicative that person is, whose land or flat, whatever it is with us. Most of the times people are not willing to communicate and to go forward. So basically, we are trying to provide as much information as we can, as it is allowed. Before every auction of immovable property, it's mandatory to have evaluation by professional. So there is some information in this evaluation document plus pictures. Most of the time pictures are from the outside, not from the inside. So this is about that. For instance, if we are selling cars or other vehicles, that's more likely that a person will be able to see, to test that thing. And usually if we're selling, I don't know, cars, there's a lot of people who are willing to apply for the auction. And usually we communicate with the owner if the person is okay, if we give that person's number to potential buyers so that they can contact directly and communicate for the moment when to see that particular thing. So was there any other questions, or
no,
I answered
thanks.
everything? Yeah.
I just wanted the issue with just a comment on what you said. We introduced a legal provision saying that if the debtor allows visitors into the premises, there will be a discount on the debt, but it is 1%. It is 1% discount, and in practice, debtors, I mean, if they're seeing that their residence is going to be sold, they don't help, and they believe, well, it's so less relevant that they don't help. So, well, I believe it's a real issue, a real concern everywhere. Thanks so much, Lina, for the clarification.
You're welcome.
Thank you, Fernando. And Lina, I will immediately give the floor to Teresa for her question.
Thank you, Anna. May I ask before my question, before Lina?
Oh, should I answer a question of Veronica?
Oh, I'm sorry. No, why don't you answer the question of Veronica? I had forgotten Veronica, sorry about that, but you have a better memory than I had, so I mentioned that only. So please do answer that question that she was posing, and then we pass to Teresa.
Yeah. So, okay, about the status of judicial officers in Latvia, judicial officers are belonging to the court system, and by performing their official duties, they are comparable to state officials. However, judicial officers are completely independent financially, so they are not state sponsored. Everything they earn is from the fees. Fees are not the right word, but I hope you get the idea. I forgot the right term. So
thank you, Lina. I believe this answers at least partly Veronica's question. Teresa.
Thank you very much, Anna, and congratulations on this excellent panel. Has been fascinating. Just allow me to say that has been a panel with the majority of women, so it's a very nice occasion today in particular. So thank you very much. I have a question regarding an issue that we have been now discussing on the chat that for me is particularly important, is to understand what is the governance model for this kind of platforms, e-auction platform, e-case management platform, how the different countries organize this problem of either having a unified state control or court monitored platform versus the possibility of having a variety of platforms. I can see that, Anna, you are explaining in the chat, but if you are so kind to provide additional information about this topic, would be very much appreciated, together with Josh, Lina, and Veronica. Thank you very much.
If I may just start, it's very simple. In Dubai, it's actually a private company that has been founded in the early 2000s that does auction in general, auction for everyone who's interested to sell items, cars, properties on their platform. And in the last, let's say maybe 10 years, Dubai courts, of course, is a big player in terms of assets that require enforcement, and they decided to outsource this service to this platform. So it's more of a public-private partnership. And of course, in terms of the transparency and governance, there is, of course, certain, like how we do it. We lately, maybe I would say 3 or 4 years ago, the IFC courts also partnered with the Emirates auction through a service level agreement that sets exactly the timelines, the procedures. From a transparency perspective, this secures the assets of the judgment creditors. I mean, in terms of debtors, basically judgment creditor enforcing against assets of debtors, and it actually provides a certain KPIs and documents and so forth. So it's actually a tri-party where the judgment creditor is actually involved, And there is huge transparency. Everything happens online and the transactions are very seamless. So that is in a nutshell the practice in Dubai. And of course, many federal and other court systems in the UAE started following this model, but it is not a court activity. It is outsourced to these private sector players through these new auction systems. I hope this is helpful.
Absolutely. If I may follow up for all of you, is there any requirement that these companies operating the platforms are established in the country where the court has adopted the particular order that is going to be enforced? Is there any establishment requirement for the platforms?
Can I give maybe some answer in that? I did not even notice, Teresa, that I was the only man in the panel, which is good, I think. Now, with regard to case management systems, you have quite a different situation, I would say. Even if you talk about private or self-employed systems, countries organize it very differently. If you look at the Baltic states, it's all state or court who owns the case management system and obliges the enforcement agents then to use it, whereas in other countries, also with a private system, like in Belgium, in France, in Netherlands, Bulgaria, etc., enforcement agents up to a certain level are free in the choice of their case management system. Are they completely free? No, because normally the monitoring and control authority will put certain demands with regard to, for example, the reliability of the case management system. At the same time, you see also that a lot of countries are more or less forced also towards a unified case management system, especially if you talk about developments like, for example, e-auction and development of e-auction software, etc. You are forced, if you want to use that software, you need to be aware that there is an interoperability with the case management system. We solved that in the Netherlands by simply saying, okay, the National Chamber develops certain software, for example, with regard to the access to databases, and then supplies this technical specifications, etc., to the different software deliverances, and then it's up to them, meaning up to the enforcement agents using a certain case management system to make the connection with that software that is delivered by the chamber. So it differs very much. The problem in a lot of countries is that the state is not always involved that much when it comes to enforcement. And that's what I was mentioning also. If you talk about the e-justice strategy, enforcement is not part of the e-justice strategy. Would that be different? Then we would have a completely different situation. But honestly, if you ask me, the best that you can do is to have a unified system. But circumstances sometimes differ. For example, if you look at Serbia, that only has a very short time that they privatized. If from the moment they privatized, they would have been able to offer a unified case management system, everybody would have chosen for that. But since it was not available at that moment, officers made different choices with regard to the case management system. So some used also the same as it is used in courts. Now they develop, meanwhile, the possibility of a unified system. But now a lot of officers say, yeah, but I invested a lot already in the case management system. So I do not want to change. And the only thing then that you can do is say, okay, let's put certain requirements to the case management system. You need to deliver data for the monitoring and control and statistics. Okay, whatever system you are using, this is how we want to receive this data, and then with technical specifications, etc.
Thank you, Jos. I think we should be transitioned to the second panel. I don't know. I saw Lina's hand up. Do you have a quick intervention before we go to the last panel?
Yeah, I just wanted to quickly clarify how our system works. Is that yes, it is owned by state and managed, like manager and holder is this court administration. However, we also have developers that are usually private companies that are chosen in the concourse from the best, and they help us purely with technical questions. And usually if something goes wrong, we have, Zoom meetings nowadays, and then all together we figure out how to work. And yeah, it's also very important, I think, that we have this unified system. So yeah, that's it from me.
Thank you, Lina. Now, thank you so much. This was extremely interesting. There would be many more questions for our speakers, but let's move to the second panel to leave sufficient time for that. And thank you again for the excellent speakers and for the discussion, which was very interesting. Teresa, I leave you the floor as a chairwoman of the second panel. We're very lucky to have with us Diana Talero and Carlos Riaño, and so we hope that there is sufficient time for you to discuss this issue too. Teresa.
Thank you, Anna, very much. We have decided to have a second panel that will complement this very interesting first panel of the workshop today by explaining a case study. The case study of how the enforcement of secure transaction is conducted in Colombia. So we have the pleasure to have with us Diana Talero and Carlos Riaño. I'm going to give you the floor immediately. Diana, thank you very much for having accepted our invitation. Let me just pick a couple of merits of your extensive CV. Diana is a lawyer, in this case, senior associate in Urdaneta, Vélez, Perla, and Abdallah Abogados. She's also a fellow of the INSOLI International, and in relation to the intervention today, she is the technical secretary of the Secure Transaction Committee in implementation of the law related to secure transaction in Colombia since 2013. She's also professor of bankruptcy, corporate law, and many other aspects in the most important Colombian universities. So Diana, the floor is yours. I will introduce Carlos after you.
Okay, good morning to all from Colombia and good afternoon for you. And thanks for your kind invitation. Today, I want to present with Carlos the Colombian case of enforcement of security rights in Colombia. Since the secure transaction reform in 2013, Colombia is developing a lot of complementary regulations to have the implementation of the secure transaction reform. I just want to highlight in this slide the different kind of regulations that introduce and accelerate the use of technologies in the enforcement proceedings in Colombia. Not just the law, but another decrees and some resolutions from the superintendency complete the legal system and robust the use of technology in the enforcement in Colombia. The legal anatomy are constructed in these standards, international standards from UNCITRAL and the OIS, and Colombia introduced the reform using that standards, but also using the standards for online dispute resolution and the implementation of security rights registry. Today, we want to highlight one of the extrajudicial proceedings that is a special online enforcement proceeding that I directed by the Chambers of Commerce in Colombia. It's a private institution, it's a private entity, but has here in Colombia a lot of public function. Today, we have a lot of cases that use this system that was in place in 2013. Right now, thousands of proceedings are enforced using this extrajudicial proceeding. and the government determines the tariffs of these special online enforcement proceedings. The tariffs are regulated by the government. And also, we want to present how these platforms of enforcement are connected with the Registry of Secure Transactions. All the cases for enforcement collateral initiate or commence with the fulfilled by the creditor of the online enforcement format that they are placed in the Secure Transaction Registry. And all the proceedings, direct payment, that is a contractual proceeding, the special online enforcement that I told that are before the chambers of commerce, or any judicial proceeding to enforce the collateral commence with this fulfilling of the enforcement format. The most used proceeding is the direct payment. Of course, because it's the special enforcement proceeding for vehicles in Colombia that are the most used collateral. But these special online enforcement proceedings are increasing the use of this special proceeding, especially for the secure transaction cases that need more sophistication, I think, are more valuable, and the recovery of the parties need to be effective, and this special online enforcement proceeding is using more every day. I want to highlight this proceeding, not in detail, that enforced by direct payment proceeding using electronic platforms, the factoring confirming platforms, to enforce collateral when the collateral is an electronic invoice. In Colombia, we are trying to connect this system with the collateral registry of Colombia to have synchronize the preference of the collateral, because the collateral registry have all these list of preferences, and this system need to interoperate with that system to have the enforcement comply with all the legal framework, especially with the preference list. And this is the scheme of the commerce could connect this special proceeding with other services that they already have, like ADR and ODR, if they develop these kind of proceedings. And I want to highlight this special regulation that Colombia enforced and issued because of the pandemic crisis, that introduced the use of the technology in all ADR, on all the judicial proceeding in Colombia, to be connected with all of these special platforms. And this special online performance mechanism has advantages. For example, has centralized files, information took directly from the Secure Transaction Registry, have this management of the cases, has automatic notifications also, has management reports. It's a document repository, and has all digital files exportable to the authorities if they need to have a judgment or a decision from this kind of proceeding. And I just want to highlight another thing. Maybe in these enforcement proceedings, digitally could have abuse for some debtors. And in Colombia, the Secure Transaction Law linked the defenses for debtor to the consumer law protection and the consumer law actions. And all of these proceedings for consumer protection are also developed by platforms. Here you can see the platform of the Superintendents of Industry and Commerce that develop all these proceedings in consumer protection cases. I want the opportunity to participate in one of these cases representing the debtor, and was very fast and has all these online hearings, and you have all the files available 24 hours, 7 days per week. And it's the maximum term to have the case resolved is one year. And I want to highlight also the public electronic auction platforms that are connected with the secure transaction law and also to the insolvency law. And in Colombia, we have two kind of these auction platforms. One belongs to the banks and and have supervision from the Superintendence of Finance, and the other it's a non-transactional platform operated by the Chambers of Commerce. We hope that in a few days or weeks, we have these platforms in function, and the supervision of these kind of auction platforms are made by the Superintendency of Company. I think I'm out of the time, and thank you for your attention.
Thank you, Diana. No, absolutely in time. Thank you very much. Indeed, I'm going to give the floor immediately to Carlos Riaño. Carlos is a business administrator, manager of the secure transaction in Confecámaras, and with a long experience in developing customer services and technology projects in, for example, the Ministry of Foreign Affairs in Colombia and many other companies in insurance and the banking sectors. Carlos, thank you very much for joining us today, and the floor is yours.
Thank you, Teresa. Good morning, everyone. It's a pleasure for me and for Confecámaras to participate in this important panel to share you how is working the special enforcement process in movable assets in Colombia. First of all, I want to share that Confecámaras is the Association of Chambers of Commerce in my country, and it was delegated by the Guarantees Law as the operator of the Register of Secure Transactions. This system allows the creditor to start an enforcement at any moment against the unpayment through the mechanisms delivered by law, as the direct payment or the special enforcement process, which has already talked Diana in the first part of this panel. This process of special enforcement is completely virtual, and it's added in the registry systems, which is considered a base of knowledge and information for the enforcement process. The system is actually used by more than 6,000 creditors, of which about 80 are traditional banks. Other creditors are fintechs, cooperatives, many kinds of funds between others, and people as you and me, which use the secure transactions of as the secure of any payment. Let me show you how it works in a simple sample. How works the platform. Please let me know if you can see my screen.
It's all yes. Thank you, Carlos.
Okay, this is the platform of the Registry of Movable Assets. So when a creditor has already registered a secure transaction and he wants to start the enforcement, what he must do is entering the platform with the user and password that has given to him. So he must go to a menu that is called Ejecución, which is the enforcement, and he must income the number of the electronic folio that was given by the platform when he registered. Let me include that. He consults the registry of the movable asset. As you can see, there is already charged the information of the debtor. In this case, the debtor is Maria Albutria. The creditor in this case is me, because this is just a demo. The state of the movable asset are going to be 1,000 plastic chair and also a type of machinery, which is extruder machine, and we are going to execute it. In general, in this moment is where we can select the kind of execution or enforcement that we're going to use as the direct payment, the special version of warranty, or judicial execution. I will go to use, in this case, the special version of warranty. I must select the Chamber of Commerce that is going to make the enforcement process. In this case, let's use the Chamber of Commerce of Bogota. And I must include the date in which I'm going to use the enforcement process into the chamber. Then we must include an estimated amount that is intended to run in the process. For example, for capital, I want to enforce 100 million pesos, 1 million of normal interest, this amount for interest of arrears, 0 for commissions, 0 for expenses of guardianship and custody, execution cost, I want to execute 2 million pesos as an example, 0 damages, 0 others, no others includes. I must make a description of the breach. In this case, is not payment. I must upload the version of the contract. So in this case, I'm going to use a select, okay. And in this case, I want to make the registration. So when this happens, the platform will notify Chamber of Commerce by an email that this creditor has started already a process of execution, of enforcement, and will start the process. In this case, what we're going to see is, let me translate this. In this case, there is saying, dear creditor, you have updated the registry of your collateral. You will be contacted by the Chamber of Commerce that you have chosen in order to start the process of the enforcement through the special method of execution. So at this moment, it's already done the enforcement by the creditor, and I'm going to change the user and I'm going to enter into the platform as the Chamber of Commerce, in order that you can see how the Chamber of Commerce see the enforcement process. Okay. In this case, the user of the Chamber of Commerce, Bogota, is going to enter to its menu and the control panel of the enforcement process, and he can see here the process that we must already done as creditor. Creditor is Juan Arturo Riano, the debtor is Maria Albutria, and in this case, the status of the execution is it's in revision. So the Chamber of Commerce can enter here in order to start the process and notify the creditor that the process is going to run already. So as Diana told you before, this is a system that has already the attachments of the enforcement process that the creditor has already started. As well is going to see the Chamber of Commerce the copy of the contract of the secure transaction, and in this case, this is a tool. This is a box where this is a chronological history of the process. For example, today at 8:45 with 48 seconds, the creditor Carlos Riaño has already started the enforcement process of the warranty. So the lawyer in the Chamber of Commerce, in this case, is only start the process. He sends a notification through email to the creditor and through the debtor that the process is already started, and he can change the status of the process in here, just given just changing the status here. It's going to, for example, approved, and he can make any observations here. For example, the creditor must pay the cost of the enforcement. And in this button, the Chamber of Commerce is going to generate automatically the certificate of start of the process. So at this moment of the process, only the Chamber of Commerce is going to start the process, and the creditor and the debtor are already authorized to enter into the process in this virtual platform. So, for example, the user of the Chamber of Commerce has already sent the solicitud de aceptación, which is the start of the process to the creditor. When the creditor enters, I want to save exit as the Chamber of Commerce, and I'm going to enter with the user of the creditor. And when the creditor enters in the platform, he can see as well, as Diana told you before, he can see as well the execution of or the enforcement process, which is going to complete some information that the Chamber of Commerce can ask him. For example, this creditor only has 2 processes of enforcement. This is the one that we created today. So the creditor can enter here into the control panel of his solicitude, and he can begin to start and complete all the information that the Chamber of Commerce could ask him besides information that he had given before. For example, he can fill these blocks, excuse me, and for example, release here that the civil judgment is going to give an is selected as jurisdictional authority. This is the description of the goods that are going to be in the process of the enforcement. And for example, here is a question that if she wants to appropriate or to sell the goods when the process has finished, and this is the amount estimated that he wants to gain in the process. And in this point, he's only given the information additional to the process. And as you can see, this platform allows them to interact, and it's important, but because they can interact between the creditors, debtors, and chambers of commerce. This is a system that has been working since 2017, and as Diana told you, we have more than 2,000 cases already used by this platform of the enforcement process. This was what I wanted to share you. I hope that you have enjoyed this presentation, and of course, I'm open to any questions that you could have. Thank you all.
Thank you, Carlos. Thank you both of you for this really interesting and detailed and illustrative presentation of a very good example of how to use technology in the enforcement phase. Maybe I would like to open the floor, Anna, first, if there is any question. Otherwise, I have a couple of quick questions for the speakers. But please, is there any question to Carlos and Diana? Otherwise, or in the meantime, if I may just to raise the following two questions. The first one is, Carlos, to which extent is there any decision that is automated, so that is not human-based? So is there any decision that is automatic or automated by algorithm in the process? That would be my question, and I will give the floor to Valeria after that. Carlos or Diana, please.
Okay, thank you. Yes, the platform is already done virtually, because we thought at the beginning when we were developing the platform that the registry has already all the information of the secure transaction. The first registry, which has the information of the movable asset, which has the amount, which has the information of the creditor, the debtors, and taking into account that the registry system is a registry which includes all the information of all creditors that the debtors has. The development of this kind of enforcement process virtually was intended that was connected to the registry, and is already a platform that allows the people interact virtually, and they have no needs of personal presence, because the platform works in a model of 24/7. So it's very easy to every actor of as creditors of debtor or Chamber of Commerce make a notification of the process online. So it's very important for our system that this enforcement process has been developed as we have done. I don't know if that answers your questions.
Thank you, Carlos. Diana?
Yeah, I think not now. We are not using any algorithm to have decisions or using artificial intelligence, but could be maybe, for example, when you need to use the jurisdiction, maybe the process to choose the judge could use an algorithm. Right now, we are not having any of these tools, but maybe in the future, I think it could be interesting to use some of those techniques or some of those measures to improve the system right now that we have right now.
Thank you. That makes completely sense, because if you have interaction, you have everything based on data, the possibilities of automation increased and are definitely very enhancing the effectiveness of the system. Thank you very much.
Yes,
Valeria, please.
Thank you very much, Teresa. And I wanted to thank all the speakers for this great presentation. I'm very interested in two aspects, at least, of these two presentations now. First of all, I would like to ask Carlo, please. Thank you for your presentation. How does this platform interact with jurisdiction and private autonomy? Maybe Teresa already asked something similar to what I'm interested into. I mean, is it an opt-in system so that when the debtor and the creditor conclude a contract, they decide that the execution procedure will take place through this system? Or is it something that the creditor could activate although the debtor hasn't agreed to that, so that the law provides for this power for the creditor to activate this execution procedure? This is one of the things I'm very interested into. And the second one is, and maybe Diana spoke about this, the ADR procedure connected to the opposition of the debtor during the execution. Like, could you maybe give me some more insights on this very interesting part? How does it work? Because it's a crucial aspect of all the proceeding. Thank you very much for both.
Thank you, Valeria. Yes, Carlos, Diana, please, the floor is yours.
Okay, about the first question, of course, our law of secure transactions allow the creditor to pact with the debtor which kind of execution or enforcement process will the creditor use against a non-payment. So if they pact in the contract of the secure transactions, they pact any of the methods of the for execution, the creditor is already allowed to use the platform. And of course, as the platform is a technological tool that he can use, of course, it allows, as I told you before, it allows the creditors and the debtors to interact with the Chamber of Commerce, which is the authorized authority to take this process on. So I think that as Diana shared us before, the next step and the challenge for this platform is in a next stage to connect with, for example, with our judges or with our courts in order to allow our judges to take the position against the oppositions of the debtor that can be given in enforcement process. That could be the question for the first question, and I let the floor to Diana in order to answer the second one.
Yes, thanks, Valeria, for the question. Yes, the interesting thing here in Colombia is that this special proceeding for enforcement, it's before the Chambers of Commerce. And the Chambers of Commerce here in Colombia have all of these services ADR services, arbitration, mediation, conciliation, and if they have the sense that there is a negotiation possibility because they interact with the parts, they could offer those services to them. And it's a very interesting thing because a lot of those proceedings are negotiating. And in not too much cases, they really execute or enforce the collateral. Some of those cases just finish with a negotiation with using ADR tools, and I think it's because the link of the proceeding with the chambers of commerce services.
Thank you, Valeria, for the great question. I don't know, you would like to reply to them as well, or just to thank
No, thank you. Just thank you very much.
Thank you, Diana, Carlos, Anna. We are already at 3:33.
Yes.
So it might be maybe the moment the time to conclude, but please, the floor is yours for these concluding remarks.
Thank you. Thank you. My remarks will only be to really thank all the speakers, because it was an incredibly interesting, short but very filled up workshop. And I hope this was also the case for our members and observers of the working group, also very useful for the development of our project. We would like, we have already asked your permission, we would like to post the recording of this, so if other people are interested in listening to it, they might do it through our website, at least through asking us, so through a system of registration, not openly, and we will send you the link in advance before doing that. So we hope that this is acceptable to you, and so thank you to everyone. Catherine, you have the last word.
I just want to say thank you. Tremendous, truly full of food for thought, and I think the working group has a lot to digest. So thank you all for taking the time. Very much appreciated.
Thank you. Bye-bye all. Have a lovely continuation of your day, short or long as it is. Bye-bye.
Thank you. Bye-bye.
Bye.
Thank you, everyone.
Bye-bye. Thanks.
Bye-bye.
Thank you. Gracias.